Good afternoon, all present. The Honorable, Right Honorable Moses Wetangula, Speaker of the National Assembly, the Deputy Speaker of the National Assembly, Honorable Gladys Sholei, the Honorable Secretary General, Commonwealth Parliamentary Association, Honorable Stephen Twigg. There are so many members here, members of Parliament, members of Senate, and many staff members of the Parliament and Senate, and many of my colleagues here. The list is long, but I request that all protocols are observed. I wish I could recognize each and everyone who viewed by name, but because of time constraints, and even I don't have the list, I see most people I know here. So thank you very much. Thank you for welcoming me here. I'm here not on my own behalf. The guest who was supposed to come and make this presentation is none other than the Honorable Lady Justice Martha Koome, the Chief Justice of the Republic of Kenya and the President of the Supreme Court. Due to other commitments which happen to need her attendance, personally, she was unable to come. She conveys her regret and apologies for not being able to come today, and she has delegated to me to represent her here. And with your permission, may you allow me to speak on her behalf. This paper was supposed to be presented by Honorable Chief Justice, and it is about leadership. The topic is leadership, behavior, ethics, and standards, a perspective of the judiciary. I had a word with the organizers, the secretariats, and I requested that the presentation, which is in writing, be circulated to all the members here for ease of reference, and either both in hard and or soft copies. I hope you have a copy, whether in soft or hard copy. To assist me, just highlight the paper, and at least you know the content of the entire presentation. So, on behalf of the Honorable Chief Justice, Justice Mohamed Ibrahim, will make her presentation. I also happen to be the chairperson of the Judiciary Committee on Elections, and somehow we saw that this program is headed post-election seminar. However, the content of my presentation has nothing to do with the elections, which were concluded in the course of last year. The presidential one, of course. We have other petitions going on right now for senators, for governors, women rep, MP, and MCAs. They were still going on, and they'll escalate to various courts, possibly also to our courts later. As an introduction, it's about leadership. So a leader, who is a leader? A leader is the person who identifies the need for change and takes the steps needed to initiate change. That might involve identifying the important stakeholders and involving them in the change process, determining possible solutions and the required resources to make the changes happen. And most importantly, leaders inspire others to see the need for change and to participate in finding a solution and implementing it. The paper is a brief rundown of the judiciary's perspective in leadership behavior, under the sub-items behavior, ethics, and standards. Firstly, by examining the constitutional provisions that govern leadership and ethics. Of course, these constitutional provisions emanated from are underpinned under the 2010 Constitution, of which you know so much about, and the basis upon which you have legislated ever since the promulgation of this Constitution. So it's nothing new to you. I'm just rehashing for purposes of our discussion. Secondly, by looking inwards at the judiciary and the mechanisms put in place to maintain high standards of ethics and performance of duties within the judiciary. Thirdly, by looking outwards through the legal framework that guides and observes the conduct of public individuals and entities. It further looks at the disciplinary mechanism and the consequences arising from failure to uphold integrity. The paper also highlights the recovery of assets as a remedy and how it has been utilized. So there will be a brief discussion about these principles as much as they affect state officers who are leaders in the country, and to some extent also an aspect of the input or the perspective of the judiciary of what we try to do to comply with these requirements of state officers, since the judges and magistrates are state officers too. What is the definition of ethics? Ethics as the moral principles that govern a person's behavior or the conducting of an activity. It is the moral principle that govern a person's behavior or conducting of an activity. It also defined as the branch of knowledge that deals with moral principles. And also another definition is that ethical relates to, of or relating to moral obligations that one person owes another in conformity with moral norms or standards of professional conduct. So we can see that ethics is not only about law, but it's about morality. And morality or morals is governed by what society does and what society thinks. Before assuming an office, a state officer must, by Article 74, take and subscribe the oath or affirmation of office and swear or affirm before God and the people and on the basis of the Constitution and the people to obey, preserve, protect, and defend the Constitution, all other laws of the Republic, and in particular to protect and uphold the sovereignty, integrity, and dignity of the people of Kenya. The Constitution at Article 260 creates a distinctive category of members of the society called state officers, who are regarded and idolized as a special pedigree of leaders in society because of the status they hold, and to whom much is given, and therefore much is required and expected. They include His Excellency the President, His Excellency the Deputy President, the Prime Cabinet Secretary, Cabinet Secretaries, members of National Assembly and members of the Senate, judges and magistrates, members of commissions to which Chapter 15 applies, member of a commission, member of a county assembly, governor or deputy governor of a county, or the other member of the executive committee or a county government, Attorney General, Director of Public Prosecutions, Secretary to the Cabinet, Principal Secretary, Chief of the Kenya Defense Forces, Commander of a Service of the Kenya Defense Forces, Director General of the National Intelligence Service, Inspector General and Deputy Inspector General of the National Police, among others. These are the main state officers. Chapter 6, which is a very important chapter, is christened the leadership and integrity. The mandate of all state officers is one of public trust, and all such officers carry the responsibility to serve the people, rather than the power to rule them. The most basic principle to guide such officers are expressed in Article 73(2). And I have set out in the paper the particulars, the details of that article, which includes objectivity and impartiality in decision-making, selfless service, honesty in the execution of public duties, declaration of any personal interest and that may conflict with the public duties, accountability to the public, discipline and commitment. All these are principles under Chapter 6. The Constitution in Article 75 makes specific provisions regarding conduct of state officers. It provides that a state officer shall behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids conflict between personal interest. And I've set out all the expectations under Article 75. I've set it out there, and also aspects of the disciplinary procedures that may be invoked when there is digression under Article 76, 77, and 78, sub-Article 2. Now, this is just generally the obligations and expectations of state officers, which includes all arms of the government. Looking inwards, I will just mention briefly, outline the standard of ethics, integrity and conduct that judges, judicial officers and judicial staff are expected to adhere to. Chapter 10 of the Constitution establishes the judiciary. The various courts and their jurisdictions, as well as the various offices in the judiciary, including the Office of the Chief Justice, Deputy Chief Justice, judges of various courts. The people of Kenya, through Article 159 of the Constitution, entrusted judicial authority in the courts and tribunals established by or under the Constitution. So the Constitution is in charge of all matters relating to judicial authority. And we know the principles that are required to be guided by the judicial authorities. This includes ensuring justice is done to all, irrespective of status, ensuring justice is not delayed, ensuring alternative dispute resolution mechanisms, including reconciliation, mediation, arbitration, and traditional disputes resolution mechanisms which are promoted, ensuring justice is administered without undue regard to procedural technicalities, and ensuring the purpose and principles of the Constitution are promoted and protected. So we have talked about, we also talk about in the issue of the requirements of the criteria for being appointed a judge and the duties under Article 172, which includes, among other things, recommending to the President persons for appointment as judges, advise national government on improving the efficiency of the administration of justice, and within the statutes that this National Assembly and Senate have passed relating to the issue of discipline, removal, and so forth, to ensure that those standards that are set out in the Code of Conduct, in the laws relating to ethics, are complied with even by the judicial officers. So we have set out under Article 75 the expectations and also the kind of actions that may follow in case there is transgression, as I said earlier. Leadership in the judicial sense is mostly viewed through reference to the cases decided or the jurisprudence developed by individual judges through their decisions. However, more recently, leadership goes beyond the jurisprudence applied effectively, with due respect, but our present Chief Justice believed in shared responsibilities and leadership to the extent that for her to effectively deliver service and carry out her functions, she has included judges in carrying out administrative functions and many other functions otherwise which are would have been confined to her role as Chief Justice. So she calls us judges to be her cabinet. So I'm also a cabinet, but in the judiciary. Now there is this Bangalore Principles of Judicial Conduct. This is a very important convention, and it settled the conduct required of judicial officers. Under Article 6 and Article 2, subsection subarticle 6, international conventions to which Kenya is a signatory are automatically part of our law, our constitution. For instance, the Bangalore Principles is now deemed to be part of our constitution. International legal standards of judicial ethics, including the Bangalore Principles of Judicial Conduct, which was adopted by resolution number 2006 stroke 2006 stroke 23 on July 26, 2006 of the Economic and Social Council of the United Nations. This plays an important role in the process of bringing the judges under responsibility. The Bangalore Principles are intended to establish standards for ethical conduct of judges. They are designed to provide guidance to judges and to offer the judiciary a framework for regulating judicial conduct. 6 core values are recognized: independence, which is very critical, impartiality, integrity, propriety, equality, and finally, competence. The Bangalore Principles have been adopted under what we call the Judicial Service Code of Conduct and Ethics Regulations 2020. So it is also part of our laws through legislation. So the Code of Conduct of Judges and Magistrates, Judicial Officers is set out in the Judicial Service Code of Conduct and Ethics Regulations 2020. I've set out the main pillars of that Code of Conduct. In the interest of time, I request you to go through that at your own time. And this, I would like to highlight some key expectations which are set out in the Code of Conduct. And these are on issues of moral and ethical requirements, Section 6, independence of the judiciary, Section 7, not only the judiciary, but also judicial officers, impartiality, integrity, propriety, and professionalism. Further, judges are prohibited from participating in any other gainful employment. Section 26, it also prohibits against sexual harassment, which is Section 29 of the Code of Conduct. A judge is responsible of his social media activities, Section 12, and should avoid activity that adversely affects his impartiality. So these are aspects of the Code of Conduct that actually you as legislators passed for us and which we have to comply. We also have got the issue of standards. the judiciary has devised ways of ensuring that the judges and judicial officers are delivering the mandate of the people of Kenya. These include the Performance Management and Measurement Understanding, PMMU, which we have submitted ourselves to. All judicial officers sign performance agreements, performance management agreements, and we have a criteria for measuring this, individually, but also in each court level. We also have regular trainings, reporting, digital automation, and case management. I've set out in the article aspects of the performance management and measurement understanding, which we have set for ourselves. And I've referred to aspects of regular training, digital automation, and case management. I have to mention something about digital automation and case management. Particularly after the outbreak of COVID, had we not adhered to or embraced technology and used the digital automation for hearings, we would not have achieved what we have achieved so far. And despite the COVID measures and the problems of meeting physically and the stoppage of physical court processes, we were able to trigger or to set out and implement digital hearings, online hearings. Just now, before I came to this meeting, just a few minutes ago, we had, the Supreme Court had 3 cases of which I participated from in my room, and fully robbed, fully equipped, and we were able to dispose of 3 cases. I was able to excuse myself from 2 others because of my ability or my wish to be with you here, so that, thank you, so that I'm able to keep the promise of the Chief Justice that I must deliver this, this presentation. So you can see how it has helped us, and the efficient disposal of cases. We're able to dispose of and settle so many cases because of this. We don't have always to go to court, and we can deal with cases from anywhere in the country where we have network. We have areas where we have problems of network, but it's a work in progress, and we are trying our best to assist the regions where there are negative, automation network problems. We also do law reporting, which is very important for the public use. We have to do law reporting so that you know, wananchi know, the academia know, legislators know the case is decided, and the jurisprudence that is being churned out by the judiciary. We also, in terms of law reporting, we have been trying to assist the media to avoid misreporting of our judgments, whereby we, apart from delivering a full judgment and sending it out there, we also do what we call a media summary, because we found out that it's a very important tool. Summary on 1 page or 2 pages of the issues in the case, and the determination and the conclusion, so that off the cuff, at a snap of a finger, the media are able to know, and because once a judgment is published, the media want to disseminate and inform, particularly very sensitive and matters touching on the public, cases that touch on the public. So sometimes, because of the nature of media, because of the nature of sensationalism, they pick a point and forget about the real content of the judgment. So we try to assist them with that, but it's very difficult. Like the last 2 cases we decided about Married Women's Property Act, they totally misled. The headlines were misleading. So I request you to read the judgments on those issues, and you will realize that it's not true that we decided against the interests of women. To the contrary. To the contrary, in those both cases, they were in favor of the women. So just go back to read the whole judgment. We also have the enforcement of standards of conduct and behavior. We have got the Judicial Service Commission, of which I'm a member, representing the Supreme Court. There are ways that we inquire into our own conduct. There are investigations are done where there's a complaint by any member of the public, court users, any parties in a court case about a particular judicial officer. We do investigations, we give them hearings, and discipline is carried out depending on the nature and gravity of the cases, to the extent of reaching up to the recommendation to the President for removal of a judge, if it is at that level. And then, of course, we have got acts of parliament that now, regarding this is now about state officers. We've got acts of parliament that regulate the conduct of judges and magistrates, and there are various statutes which have been enacted to enhance ethics of public and state officers. For instance, the Public Officer Ethics Act 2003 is an act of parliament to advance the ethics of public officers. Now this cuts across the entire public service. It provides for the code of conduct and ethics and requiring financial declarations from the certain public officers and to provide for connected purposes. There is what we call this annual, every 2 years we normally have to fill out we have to make declarations. I think it applies to all public state officers, the declaration of wealth. Many times we call it the declaration of poverty, depending on your pocket or your bank account. So the Leadership and Integrity Act is another statute, Act number 19 of 2012, which gives effect to and publishes procedures and mechanisms for the implementation of Chapter 6 of the Constitution and for connected purposes. As I had mentioned, we have the Public Officers Ethics Act. I've set out provisions of that. I request you to go through them. I have set out an outline of the Leadership and Integrity Act and what they speak about. Leadership and Integrity Act is an act of Parliament to give effect to and establish procedures and mechanisms for the effective administration of Chapter 6 of the Constitution and for connected purposes. I think you know this very well. You know the details, and you as Parliament, both the National Assembly and Senate, have invoked these provisions to make inquiries into conduct of not only your members, but other state officers too. We have disciplinary procedures under our law. We have a process for removal of a member of a commission or an independent office. I've given a case, an example, a case of Omkia Mtata Koiti versus National Assembly of Kenya and four other interested parties, versus including the former Auditor General Edward Ouko and 5 others. The court, in a case challenging the mandate of the National Assembly under Article 251, the court dismissed the petition and held that Article 251 was clear of the National Assembly's mandate to hear petitions for removal of members of any independent office. We have the law relating the removal of governors. You have dealt with it, you have applied it in at least 2 cases. The removal of the governor has been successful twice. It has been utilized on 2 occasions. The case of Mike Sonko Mbuvi, Gideon Hyoko, Nairobi County, and that of Ferdinand Waititu in Kiambu County. So you can see how these laws are working in the interest of the people of Kenya. We have got laws relating to forfeiture and asset recovery. The Asset Recovery Agency, through Process of Crime and Anti-Laundering Act, number 9 of 2009, has recovered assets that have been determined to be proceeds of crime. The records show that this ran into billions, showing the kind of use and importance of this process for recovery of proceeds of crime. The East African, the Ethics and Anti-Corruption Commission, through the Anti-Corruption and Economic Crimes Act No. 3 of 2003, has through forfeiture recovered unexplained assets. As of 4th March 2022, that commission has recovered properties worth 30 billion, with the civil cases filed in various courts across the country to recover public assets valued at 14 million. The judiciary has done its role through setting up of the Ethics and Anti-Corruption courts and through hearing of petitions presented to the proceeds, presented under the Proceeds of Crime and Anti-Laundering Act No. 9 of 2003 and the Anti-Corruption and Economic Crimes Act No. 3 of 2003. We have given an example in that paper of one case, Stanley Mombo Amuiti, and whereby this forfeiture as a form of remedy, a fair remedy, has been applied to recover assets that, that cannot be explained, and criminal forfeiture requires a criminal trial and conviction, while civil forfeiture is employed where the subject of inquiry has not been convicted of the underlying criminal offense, whether as a result of lack of admissible evidence or a failure to discharge the burdens of proof in a criminal case. As I conclude, I would say that the role of the judiciary is defined in the Constitution under Chapter 10 of the Constitution, with Article 159 mandating the judiciary to protect and promote the purposes and principles of the Constitution. History provides us with many lessons to be learned from great leaders of the past. There are those who quickly rose to power and showed promise of extraordinary success before ultimately falling into grace. There are those that, despite their great wealth and charisma, were not well equipped for leadership as they lacked honesty, humility, and a servant's attitude towards leadership. There are also those that, despite being wise, were consumed with the pursuit of wealth, fame, and power. The main reason that history repeatedly reminds us is that there is great correlation between leadership and accountability coupled with integrity. Thank you. The judiciary's leadership on perspective on leadership, behavior, ethics, and standards is for it to ensure that constitutional principles in this regard are maintained, not only within itself, but by the very institution of or office working for the betterment of the people from whom its authority is derived. That is the people of Kenya. I thank you, and God bless you all. Thank you.
Thank you very much, Justice Ibrahim. You may have a seat.